in the name of personal injury law.
When we hear about personal injury cases, we may not think about the fact that if we're injured because of the wrongful conduct of the government, our rights are different than if a private citizen or a company injures us. Today we have with us Steve Sinas, along with some of his colleagues from the Sinas law firm, to talk about the complicated and limited rights that we have when we're injured by the actions of the government. And specifically, we're going to talk about how those issues play out with the Flint Water Crisis. Welcome back, Steve.
Thanks so much for having me. It's great to have my colleagues with me. I have law firm partner Jim Graves, who's had an illustrious legal career representing various personal injury victims across the state of Michigan. He's had various cases against the government, and he's led our firm's litigation with regard to the Flint water catastrophe. I also have John Homa, who's also been involved in the litigation of the Flint water cases we have. And when it comes down to this area of law, let me just try to set the stage here. People may not understand this, but if the government injures you and was negligent in doing so, it has immunity from you bringing any lawsuit against it, unless you can fit within a certain statutory framework that's laid out. It's hard to summarize that, but there are very limited exceptions. And there are many instances where people are injured as a result of the negligent conduct of the government, and they have no remedy. And so when you're looking at the Flint water crisis, you may think, well, the evidence showed that the government did negligently at least poison the people with leaded water. Can't they be held accountable? And the starting point is no, unless you can find an exception. And there wasn't really an exception in the statute. And so what Jim's going to explain is how the Constitution provided a certain remedy to these people that normally isn't there for other people who are injured as a result of negligence by the government. So Flint water was this horrible situation, and thankfully there's a constitutional right that the courts have recognized, but that's a very unique scenario in these cases against the government. So Jim, if you could explain that further, that'd be great.
Thank you, Steve. You're absolutely right. The exceptions to governmental immunity, which protects the government from being sued, are not available here. We don't fit within those exceptions. So what the lawyers on behalf of the citizens of Flint were able to do is fashion an argument that the U.S. Constitution was violated. Specifically, what we call a Section 1983 claim was brought, which means that the government here, by opening the faucets to the Flint River water, which was poisonous, was a deliberate act to the indifference of the safety of the community, that it was arbitrary, capricious, and was so wrong that there's a constitutional violation referred to as a violation of one's bodily integrity. And so that is the legal basis on which then the judge in this case found that these cases can go forward. They cannot be dismissed at the outset based on governmental immunity.
So what's the reality of the litigation over the Flint water crisis?
Well, the Flint water crisis has been in litigation for years. It has been a very complex litigation in multiple courts across the state, including our home state courts, the Michigan State Court of Claims, which is a venue for suing state actors or state of Michigan employees, and also in federal court. And one of the most complex parts of this case is the sheer number of individuals injured and seeking redress for their injuries. To date, there are over 30,000 individuals who have been injured by the Flint water. There's also multiple defendants and actors who played a part in the role of switching the Flint water to the public. So therefore, there are many different types of claims, defendants, and different legal theories, as Jim has alluded to, which are unique to this case and make it quite complex as far as litigation goes.
So I heard there might be a proposed settlement. Jim, could you tell us a little bit more about what that means?
I will, Lisa. A few weeks ago, the state of Michigan announced that there has been a tentative settlement reached on behalf of the state of Michigan and the governmental officials with representatives of the plaintiffs who brought this cause of action. And under the terms of this tentative settlement, it's a $600 million settlement to be distributed to the citizens of Flint. But it has not been finalized, and there will be an opportunity for additional residents to come forward and make their claims at a later date. So the process will go on for many months. Probably, in all likelihood, no distribution of funds will be made until sometime next year.
So would this settlement, if it was accepted, would it resolve the cases of those 30,000 claimants that John had mentioned?
No. In fact, there are other defendants, other parties who have been sued, including engineering firms that assisted the city of Flint and made recommendations that were not followed by their own engineering people to allow this to happen. And so those cases are being brought on a professional negligence theory. Those cases will continue to go forward.
And can you tell us a little bit about like the types of injuries that the people of Flint have suffered, what that money is supposed to compensate them for?
Primarily to the children of Flint who ingested lead, which is a neurotoxin and affects their intellectual ability, and also for those people who contracted Legionella and either were severely harmed or died as a result of Legionnaire's disease.
And let me try to tie this all together for the viewers, because I know it's a lot to take in. But one thing we want to make sure people understand is that there really is this unique set of rights that's very limited when you are injured as the result of the negligence of the government. And that is based on legal doctrines that were part of our nation's law hundreds and hundreds of years ago, but then has been codified by statutes that have been passed by our elected officials that further limit and create all these procedural requirements for people to follow, different standards that apply, that all make it really difficult to obtain justice when the government is the negligent actor. And we can have our debates about whether that should be the case or not, but people need to understand that's the reality and think about whether or not that really makes sense. To some extent it may, but some of these procedures that the people of Flint have had to deal with in terms of how they litigate their cases and these notice requirements, that's one thing we haven't talked much about, but one of these unique requirements is this need to notify the government of your intent to bring the claim after so many months, so many days, so many years, whatever may be the claim. And if you don't do that, then you just don't have any claim at all. And some of these things are just patently unfair. And we just really want to bring more awareness to people about it so that they're not surprised if they are injured, and that they certainly know so they can maybe advocate for better change.
Now, one last question. You mentioned there are cases in federal court and state court, and is the settlement specifically for the federal court cases?
No, this would be an omnibus settlement on behalf of all state defendants.
Okay. Any closing thoughts, John or Steve?
No, we're just happy to be able to help these people in this catastrophe and hope that people have more awareness about this issue.
Gentlemen, thank you so much for helping the citizens of Flint.
Thank you, Lisa.
In the Name of Personal Injury Law is brought to you by the Sinas Law Firm.